You may begin.
Very good morning to all. It gives me immense pleasure to welcome all to today's webinar. I, Advocate Megha Patil, welcome all on behalf of Sri Vasantrao Patil Lawyers Training Center, supported by Sangli Bar Association. The training center was established in 2019 in the memory of late Advocate Vasantrao Patil. He was renowned criminal lawyer and ex-president of Sangli Bar Association. Many advocates, including me from Sangli and Kolhapur district, received his blessings and valuable guidance from time to time. The aim of the center is to provide guidance to the upcoming young lawyers with overall development, with imparting legal knowledge, professional ethics, and legal conscience. With this spirit, the center has till date arranged number of lectures of renowned faculties. And today we are privileged to have one of the renowned faces of Bombay High Court, Senior Advocate Rajani Iyer, Madam. Thank you, Madam, for joining us today. Now over to Ingavle, Ma'am. Thank you.
Ingole ma'am, unmute yourself.
Thank you, Megha ma'am. A woman with voice is definition of a strong woman, and it is my privilege and an honor to introduce to you a strong woman who has walked the corridors of the Bombay High Court for over 4 decades fiercely and broken the glass ceiling, setting aside the prejudices. Today's speaker is none other than Ms. Rajani Iyer, who needs no introduction. Ma'am completed her graduation from the St. Xavier's College with BA Honorary in Economics and went on to complete her Master's in Economics from the University of Bombay. Ma'am is also a member of the People's Union for Civil Liberties. During her graduation and master's course, Ma'am actively took up the espoused cause of the students, ranging from facilities and better infrastructures to introducing internal assessment in addition to the terminal and yearly examinations. She took up teaching for a brief time and taught economics at the undergraduate course at the Queen Mary School, MMK College, and Burhani College. It was during the emergency that the curiosity about the hows and the whys of the Rajanarayan case led Ma'am to join the field of law. She completed her LLB from Government Law College in the year 1978 and went on to become a solicitor in the year 1979. In the same year, Ma'am joined the Chamber of Legislators District, where she worked for the famous Antule case, the IGPP trust case, etc. Ma'am is amongst the three women to be designated as senior counsels of Bombay High Court in the period from 1991 to 2010, which is an astounding period of 19 years. In her career span of more than 4 decades, Ma'am has not only concentrated on her legal profession as a career, but has also used it as a weapon to work for social causes. She has appeared in various PILs, assisted the Bombay riot victims before the Justice Sri Krishna Commission, the Huntman Dwellers case, noise pollution case, FSI cheating matters, etc. Ma'am has also taken up various issues as faced by females and children. She has always loved to conduct cross examination and is a supporter of the alternate dispute methods. Ma'am's achievements are endless and would take me an entire day to list them all. However, with no further delay, I request Ma'am to enlighten us with her expertise and enrich us on filling up the lacunas in trial and preparation for final arguments. Thank you, Ma'am. Over to you.
Good morning to all of you. Megha, Vijaya, thank you for your lovely introduction. I'm touched. I also thank the Vasantrao Patil Lawyers Training Center and the Sangli Advocates Bar Association for giving me this opportunity to be with all of you who are attending this webinar. Two little asides. Vijaya shared with you that I was involved in the profession of teaching. I was teaching economics because that's what I mastered in. But the economics of teaching economics forced me to come to law because I was earning a handsome salary of 300 rupees per month. And that was just not possible for me to keep myself afloat. I had to borrow from my parents. Today, when we are doing this webinar, a lot number of us are finding ourselves in the same position. And that is why I share this small aside with you. Given today's topic of filling up lacunas in a trial and preparation for final arguments, all of us must keep in mind that perhaps a time for trials and final arguments may not be round the corner in all courts in the country today. But we have to prepare for a time when we will be preparing for final arguments down the road. Therefore, what I'm going to be sharing with you today is somewhat based on what is contained in the procedural textbooks, some on the basis of what I have seen happening in court, and some on the basis of my personal experience. My personal experience as an advocate who happens to be a lady practicing in the Bombay bar has been that it has been a struggle well worth the struggle and well worth the while. Therefore, all of us, please let us not lose heart. Some of us are not as well placed as others. Let us try and reach out to them and see whether we are going to be in a position to help them during these distressed times. Coming now to what subject we have to address. Filling up lacunas in the trial and preparation for final arguments, these are the two sections of the discussion today. Where would the lacunas in the trial have occurred? Let's deal with that part of it first. What is the trial? When is it supposed to be a trial? I'm going to take the stage of recording of evidence as the trial stage. So everything which has happened prior to the stage of recording of evidence is the period or are the stages in which certain things remain to be done or certain things are found to be wanting when and how we reach the stage of recording of evidence. Prior to the recording of evidence, therefore, what is there on record? What is on record is essentially two things. One, the pleadings. And Justice Joshi was so clear in his address in the first of these three webinars that have been conducted by the Sangli Advocates Bar Association and the Vasantrao Patil Lawyers Training Center as to what ought to be there in pleadings and what ought not to be there in pleadings. That is an eye-opener as to what are the shortcomings that one may face in averments, in details, in the pleadings, which have to be corrected prior to going into the stage of recording of evidence. Mr. Nafde was very clear in his address yesterday about what is evidence, how is evidence to be seen, what is to be recorded, and how it is to be appreciated. So with these two building blocks already in place, very many of the queries that one may have as to what are lacunas which require to be filled up would already have come to your mind. It is the importance of filling up of the lacuna, which I would like to take some part of your time today. Apart from pleadings, the second important thing which is in place by the time you come to recording of evidence are documents. I cannot emphasize the importance of documents which are on record and which form the bulk of the basis from which you glean the facts and on which you base your case. Documents are far better than oral evidence. It is the best evidence. You may even have a stage or a matter in which the documents are so crisp and explicitly clear that you may eschew oral evidence and go only on the basis of documentary evidence. In fact, even law acknowledges this when they say that the summary suit doesn't require oral evidence because the document is so crystal clear. You can just base your case on the document and you can hope and aspire to get a decree, or because it is so clear, your client may be told that there is no defense available to him or her. For us to know what lacuna required to be filled up, each of us will have to study each document very carefully. Without seeing the devil which is in the small print or the fine print of the document, it may sometimes turn out that we have not appreciated the existence of a pitfall and are therefore ignorant of a lacuna which requires to be filled. Let me give you an example. There is a contract arrived at between A and B. B is to undertake a particular project based on certain rules and regulations put in place in respect of that particular item or matter by the government. Do you treat it as a simpliciter contract which has not been performed by B and which A wants B to perform and in respect of which a suit has been filed, and not read the rules and regulations of the government? Or do you need to read the rules and regulations in order to point out that the rules and regulations require X, Y, Z to be done, and B has not done X, Y, Z, but has only apparently complied with the terms of the contract between A and B? Now, why I say this is that the rules and regulations require X, Y, Z to be done, or ABC or PQR, whatever it is. Have you sufficiently understood how and why that would have an impact on your contract? Is that an area which has to be examined for finding out whether there is a lacuna in the defense being set up or in the case being forwarded by the party to the suit, which requires clarification? Has this clarification come on record in some other document? That document is not being admitted by the party against whom it is? If that be so, how do you overcome this lacuna? Because once that party gets to a stage where they have to admit that document, perhaps the quantum of evidence that you have to leave will be reduced. Remember, this is what Justice Joshi also said in his address, that we have to resort to the provisions of CPC. Something that even Mr. Nafre emphasized yesterday, that you have to go to the provisions of the CPC to reduce the quantum of evidence that you leave at the trial stage. Therefore, the disclosures and the documents brought on record, not marked on the record, but brought on record by the parties, has to be very detailedly studied by us as advocates, appearing for either side. But our attention has to be on the pitfalls, if any, that we are able to glean from a study of these documents. Once that is done, then we can do something about it. Now, this reading of documents is part of the preparation for your final arguments. So it's an integrated thing that we have to face, because the stages involved in the preparation of final arguments are manifold. To start off with, reading the pleadings and the issue. The second thing that you have to do is you have to read and appreciate the evidence which has been recorded, because now we are past the stage of recording of evidence, we come to the final argument stage. We also have to read the applicable law. Is it transfer of property? Is it contract? Is it MOFA? Is it what? Rent Act? What is it? Once these three have been done, or these two have been done, because if it is the stage of recording of evidence, it would be the pleadings, the issues, and the applicable law which you would have read, and you will try and plug the holes as far as the stage of recording of evidence comes in. If it is preparation for final arguments, then you would have read all three, at which stage also you might be in a position to do something about plugging some lacuna. But what is that? We'll come to that in a minute. But what are the other stages for final argument? Because the other stages are also important for you to be able to appreciate the existence of a lacuna. And that is the preparation of a detailed list of dates. You may have to prepare two lists of dates. I never go into a hearing without a detailed list of dates and events. That is your Brahma, whatever it is called, your basic bomb, which is you have in your hand. And this list of dates would have to be on the basis of pleadings, both the plaint as well as the written statement, whether a particular date has been particularly said in a particular manner, and that date has been explained in a different manner. You have to know both of this when you're putting your questions in cross to one or the other side. The second stage at which you will have to have a detailed list of dates is after the recording of evidence, when any dates or any contradictions which you are able to glean from a reading of the evidence also, you incorporate into this list of dates, which is the detailed list of dates. With this list of dates, for the preparation of final arguments, you also have to have a list of propositions of law. Why is a list of propositions of law which is required at this stage? Having read the applicable law, having read the pleading, and having read the evidence, you will have to make your submissions about whether the provisions in law have been complied with one party or the other, depending on whom you're appearing for, and the manner in which you present its absence or its existence will be the proposition of law for your submission. Because the law, even the judge will know which law is applicable. But the proposition under that law, like for example, arbitrariness, Article 14, the judge may know that. But whether there has been compliance with the requirement of non-arbitrariness is dependent upon the submission regarding Article 14 and the manner of its presentation. So your proposition of law must be very clear, set out both in your mind and in the note that you prepare for yourself. Once this proposition of law is clear in your mind, because you've read the pleadings and you've read the evidence, for submission to court, how do you integrate the law and facts on the basis of pleadings and the list of dates is the next important aspect. And lastly, given the time that we are faced with today, and even earlier, a lot number of us used to do it, we always prepared written submissions, issue, proposition of law applicable, and then an appreciation of where this is reflected in the two pleadings, which are the questions or paragraphs in which it is reflected in the evidence, and then your submission on the basis of all this. Why is it necessary for us to go through these 7 stages? I just quickly repeat them so that if you are making notes, you will be able to just jot them down. Reading of pleadings and issues, reading of evidence which has been recorded, a reading of the applicable law. Just read the bare act. And the importance of reading a bare act, I'll share something with you. A preparation of the list of dates on the basis of the pleading. Based on the pleadings, your preparation of propositions of law. Based on the reading of law and the pleadings, your list of dates, integrating the list of dates into the list of dates, anything that you get from the evidence. And then the integration of law and facts with reference to each issue. In respect of issue number 1, which are the paragraphs in the pleading and the written statement. How is the averment? How is the denial? What is the denial required in law and why it could not be there because the averment is not there in the pleading? How can you expect the defendant to deny something which is not averred if you're appearing for the defendant? If you're appearing for the plaintiff, this averment is required in law. It has been made, but it has not been denied adequately, as is required in law by the defendant. This integration of law and facts with reference to each issue. And lastly, all this set out in one paragraph issue-wise. And then set out, if you have time, any important and eye-sockingly important question to which there has not been a sufficiently good answer in the course of cross relating to the chief filed by the party or any document disclosed by either party. So it is evident that it is only on undertaking the first 3 or 4 stages of the preparation for arguments that the lacuna to be corrected will be appreciated by us as advocates. The first hurdle that will face you while trying to breach the lacuna, because that's what we are now going to examine, will be the aspect of delay. Now, as far as delay is concerned, over a period of time, the courts are appreciating that delay cannot really be something which can prevent a party from seeking to bring the correct facts and facts which are in issue and required to be resolved by a court before the court. So don't be obsessed with delay. Delay is something that the courts today are slightly relaxed about. What they are not relaxed about are laches and delay. If there has been laches or delay on the part of a party in seeking to correct a lacuna, you should be able to explain why there has been such delay and laches, how such delay and laches would not affect the merits or advantages or disadvantages, the merits or advantages of the opposite party's case, or would not put them at a disadvantage or cause unnecessary advantage to your side. And lastly, how the germs of the lacuna which you are trying to fill in already exist on record, and you are merely trying to clarify it. So if it is clarificatory that the amendment seeks, clarification that the amendment seeks to bring about, then try and link it up to a document already on record try and link it up to a pleading or a fact already reflected in your pleadings and show how it is for ease of trial that this particular lacuna is sought to be filled. Additionally, if as per the applicable law, whether it is textual or judgment law, the required averments and documents have already been reflected in the pleadings, your task becomes easier. If it is not, and you are seeking to bring them on record, then you need to make an application under Order 6, Rule 17 by taking out what we call an amendment application. As person given the charge of conducting the final argument, if you notice it before final arguments, do so. It may be that you are not involved in the recording of evidence, but then to see whether you can, after putting your client on notice that this is a stage which is not prior to trial, but it is after the trial in that sense. The client may not understand because for him or her, since the arguments have not been completed, the trial is not yet over. But technically, the trial may be over because recording of evidence is over. But if you show a readiness and a willingness that yes, this is required for the court to come to a correct finding, and yes, because of a default on you or your client's part, it may involve additional evidence, but that additional evidence may be a small cost to bear, given an incorrect determination of the real issue, then the court would have, even at that stage, the power to do the needful, but on terms. So it is the manner in which you are able to read the pleadings, read the evidence, and correct the lacuna. And the willingness on your client's part to acknowledge any default on your part or their part in not having brought a particular fact to your notice, or the fact that you, as an advocate or a lawyer, failed to observe that in the past for any number of reasons, absence of clarity of instructions, sometimes just volume of work involved in the matter, that you require this indulgence from the court and communicate to the court the need, not the wanting of the amendment, but the need for the amendment, that the courts would be persuaded. Now, such amendments are permissible by courts only, one, as I've already said, under the provisions of Order 6, Rule 17, before the trial begins. I've already explained that in some detail to you. And most important, and this is what I will emphasize and re-emphasize and keep emphasizing ad infinitum, if it is necessary to determine the real question in controversy, whether the amendment be vis-a-vis a party, vis-a-vis a cause of action and the bundle of facts which constitute the cause of action, and vis-a-vis the relief. As far as party and relief are concerned, I will address that in passing, in short. Misdescription of a party, not a problem, but required to be done so that execution does not become an issue. If you are the plaintiff, misdescription of a party would be important when it comes to avoiding execution if you are the defendant. You may therefore want to oppose it. What are the facts on the basis of which you can oppose it? That this entire application was delayed for so long because the plaintiff wanted to harass me, the defendant, despite knowing from the start, because of my averment in my written statement, because of dealings with the correct plaintiff since prior to the plaint. All these are facts that you can bring to the notice of the court, which the court can be persuaded to keep in mind at the time of passing of the decree, even if the amendment application is allowed, which the courts may keep in mind at the time of awarding costs, both on the application as well as in the suit, if and when the application is allowed, subject to costs, if and when the suit may or may not be decreed subject to costs. So you may, for example, have a situation where despite the decree being passed in favor of the plaintiff may have to pay costs to this defendant. Because of the facts of the case, I'm not going into the merits of the facts of the case. All right? I'm just giving you the manner in which you have to approach it. It cannot be, I am right, I am right. There could be room for improvement. We are sorry that improvement was not done. All this is part of the manner in which we approach the court. The court is there to bring about justice between two parties. Let us not ever forget that. Your client may be right as far as you are concerned. Your client's actions may be under a scanner as far as the court is concerned. That is the approach of the courts, which we always have to be alive to. Such an application, apart from it being before the trial and with reference to the real question in controversy, if it relates to the cause of action and a wholly new cause of action is sought to be brought in, it may not be successful. If it's an alternative plea which you want to add, the basis of which is already there in your pleading but has not been crystallized in so many words, it may be permitted. And all this that I have said presumes that there is an application made by the party concerned. So such amendment is permissible only on an application made by the party concerned. And such amendment may be permitted only on terms that the court considers as just. What is this just? What is this aspect of just that the court keeps in mind? A couple of things. One, at the time of amendment, even if the opposite party raises the issue of limitation, the court may say, limitation is a question which is a mixed question of fact and law. Evidence may be required, so the amendment is allowed subject to the plea of limitation. That could be one of the terms. The second term could be costs. Generally, it is costs, because limitation and costs is all that is really required to be considered at the amendment stage. At the final hearing stage, where these other aspects come in, it's a different matter. And such amendment, if allowed, is directed to be carried out within a particular time. Now, why is this particular time important? This time is important because the court knows its register and its roster and may give you more than 14 days. If the court does not specify, the Act specifies that it shall be done within 14 days. If for any reason the paper is not being sent back to the registry, for example, you have to apply to court and have the time extended. But it has to be by a date set by the court, because once you have submitted to the court is the master of the matter, and you have to follow the requirements as specified by the courts. Now, this is as far as pleadings is concerned. What happens if a very important document, which you, while studying the matter, find is important, and you find it's not on record, it's not being brought on record by either party, then what happens? Depending upon the stage at which you are briefed in the matter, or you are associated with the matter, if you are associated as an advocate on record, then the stage is at all times. You must, prior to the trial, prior to evidence being led, and when I say evidence being led, I mean affidavits in chief or oral cross-examination being led, you can do a couple of things. Along with the plaint of the written statement, Justice Joshi has said that you have to have that list of documents that you rely upon, which has to be annexed. Along with that, you also have a compilation of documents which you submit to the court. I remember as a beginner, if I got the order in the directions court, we had something which was called the directions court. When every court came up before a judge in chamber, and the chamber judge said long causes, commercial contested short causes, commercial causes, whatever it is. If you were able to get an order of 666, service, written statement, and discovery and inspection, 6 weeks each, you could happily mark 100 rupees for that. And your day would be done. Especially if it was otherwise a long cause, which the court says, no, this is something which is a regular call and 666. You could then mark 150 rupees. Compared to my 300 rupees, that was wow. Now, here we find if the documents are not there in the list of documents, are not there in that compilation of documents, which are filed along with the pleadings, and your client has told you something which you find is important enough for you to bring it to the record, you have the provisions of Order 7 in case of the plate, Order 7, Rule 14, and in case of the written statement, you have the provisions of Order 8, Rule 1A. That these documents, which have not been produced with the pleadings but are required to be produced, cannot be relied upon without leave of court. Now, why is it necessary for you to have that document on record? Because if you try to bring it on record, you will have to ask the scanner and the inquiry put to you by the court. So you have to have a good enough reason. Can you use this document and bring it on record by way of cross? Because there are limited documents that you can put to a witness in cross. If you cannot bring it to his or her attention in the course of cross, is there a stage which is applicable to you? A provision in the CPC which is applicable to you, through which you might perhaps be able to put it in cross to the witness? Yes, there is. Order 11 and Order 12. I'll come to that in a minute. But all this has to be done, whether it is an averment or a document which requires to be there in the pleading and which is not in the pleading, and which should be brought on record, all this has to be done before trial, before evidence is led. Why before the trial, and why only with the leave of the court? Because of a couple of reasons. The court has to reframe issues before the evidence is led. Because you normally read your evidence with reference to the issue. And it also has to decide about the admissibility of the document before the evidence. remember the importance that Mr. Nafre put on the various stages of reading evidence yesterday. This is something that when I was hearing Mr. Nafre yesterday, brought to my mind what Mr. Lalit Chari, the late Mr. Lalit Chari, an eminent criminal lawyer at the Bombay Bar, used to din into our heads, even though we were not in any matter with him, but just used to sit around him because he was such a master of the law of evidence. That evidence is really about 4 or 5 stages. First, whether a fact exists. May exist, but is it relevant? It is relevant, but is it admissible? If it is admissible and it gets admitted, how do you prove that document? So that it can be read in evidence. Why should it be read in evidence once it is already marked in evidence? Because the manner in which you read it into evidence will determine its probative value. And whether you have made a success of it will be reflected in the course of your arguments and how you present that document in the course of your arguments, and whether your arguments have been accepted as is reflected in the judgment. So there are so many different stages, even as far as evidence is concerned. But both your plea as well as your document must be brought on record before the evidence is led, so that the court may have a chance to frame an issue, reframe an issue, or delete an issue based on your plea or based on the documents concerned. Once the lacuna in the pleadings and in the documents on record is attended to, now is the time when you set your mind on the reduction in the volume of burden of evidence. It's not a lacuna that you are seeking to fill in, but it is as important as anything for the manner in which you prepare for your final arguments. Once the entire bundle of facts are on record, bundle of documents are on record, and there's something which is not there, give notice under the provisions of Order 11 or Order 12, depending on whether you're the plaintiff or the defendant. And bring into play each of the forms in Appendix C of the Civil Procedure Code. If any of you have a CPC nearby, you will find that all the forms in Appendix C really deal with forms by which you have to obtain orders for discovery, inspection, interrogatories, admissions, notice to produce documents, etc. So read, study the provisions of Appendix C. Very important. Once I go through this, I will give you an example of how I first came face to face with the importance of Appendix C provisions of the CPC. Way back in 1980s, very soon after I joined the bar. You have provisions where you can give notice with leave of the court to the opposite party to discover documents. That is, to disclose documents, to give inspection of documents. You can even give notice to answer interrogatories. You can ask the opposite party to produce specific documents. Disclose is different, produce is something else. Why? Because your discovery application is disclose voluntarily all the documents in your possession relating to the matter. Notice to produce document is whereby you're saying, I know this document exists. This particular document has not been disclosed by you. I therefore call upon you to bring it to court. Once such a document is brought to court and you have a look at it to see whether it is the document that you wanted which has been produced, and you take inspection of that document, then there are two things that you have to be aware of. Given the provisions of section 163, 164 and 165 of the Evidence Act, that such a document, once you give notice to produce, it is produced and you get inspection of that, or you take inspection of that rather than get inspection of that, take inspection of that. Then even if it is a document which turns out to be against you, you can be called upon by the other side to mark it into evidence. So you run a risk. It depends upon you and your astuteness, whether you want to give this fact away that the document is against you, or you treat it like any other document because you know what is there. You're just trying to test out the other side and you don't ask for inspection of that document. Or having asked for inspection of the document, you wait for the other side to default and not ask for it to be marked in evidence. Or alternatively, even if the other side asks for it to be marked in evidence, hope that they will not know why you do not want it on record. Now, all this is you play by the ear, as we call it in court. On the other side, if you give notice for production of a document and the other side fails to produce it, remember, you might be the party asked to produce a document and your client says, I will not give you this document to be produced. You are creating a lacuna in your own client's case because there can be a presumption which the other side can ask the court to draw against your client. That there is something in this document which is against that party, which is refusing. And what that is something that the opposite party who has called upon you to produce that document may lead evidence about. And you may not be able to rebut it. Therefore, all these provisions regarding notice relating to documents has also got another manner in which you can ask for the documents to be proved without having to lead evidence about the documents produced by your own client. And that is, give notice to admit documents or to give notice to admit facts under the provisions of Order 12 to the opposite party. So even though pleadings have been completed, documents have been led, before the evidence begins, try and give scope for these provisions of the CPC to come into play if you feel there is need for it. Because once you give such a notice and there is non-compliance with such notice by the other side, there are two things which can happen. One, you can make an application to court asking the court to direct the opposite party to comply with the notices issued to them. And if after such order is obtained by your client on such application in their favor, there is still non-compliance, you can ask for adverse inference to be drawn. Two, if you don't make such an application to court for compelling the opposite party to disclose, then too you might have a win-win situation where you may be able to convince the court that I gave notice, I gave reminders, but there was no response at all. Not forget a refusal, but there was no response about even acknowledgement, because these notices have three parts in them. One, I have received your notice. I hereby disclose and or answer your notice to disclose documents, produce documents, answer queries, admit facts or admit documents, and I object to doing so. So you can try and convince the court that there is no objection also which is recorded by way of an affidavit to the notice, and therefore an adverse influence has. Now, this leads to a lot of reduction in the quantity of evidence which you need to leave. But sometimes it may be very difficult to go to this because you have only been consulted at the stage of final arguments. If that be so, then the only remedy which comes to my mind at this stage for getting a document which you want as an arguing counsel on record is to give notice to produce documents at the time of arguments or kept in the tribunal. That seems to be the only way out. On the other hand, depending upon the sagacity of the court, the judge, depending upon your appreciation of how the judge is looking at the matter so far, and if you have sufficient instruction from your client and your client has sufficient confidence in you, I would still urge you, if it is a very important lacuna, to try and seek the indulgence of the court to move an application for filling up that lacuna. Why? If certain amendments can be allowed at the appeal stage, or may I say, even at the appeal stage, why cannot an appeal court look upon your application attempt just prior to arguments with an indulgent time? Keeping that in mind, but without being abrasive, without being too boisterous about it, you have to seek the indulgence of the court and submit to the terms that the court may impose on you. And that's where the confidence between you and your own client comes into play, and make such a application. Once all these documents are there and you have got them admitted because of the notice to admit documents or facts, then remember, in the course of cross, you don't have to prove these documents. You may not have to prove that documents depending upon the answer that you get to your notices. But today, with a lot of evidence being recorded before commissioners, I find that the appreciation of evidence recorded by commissioners are relating to a point in time when courts did not have the clarity because of certain subsequent judgments at the time of reference of matters to commissioners for recording evidence regarding documents to be marked or not being marked prior to evidence and cross-examination before the commissioners. Therefore, prior to your final oral arguments in the matter, if what you are dealing with is evidence recorded before a commissioner, you require very clearly to point out a couple of things. The documents on which certain cross-examination was undertaken in the course of the recording of evidence before the commissioner was on documents which are disclosed but not clearly are not admissible and therefore cannot be marked in evidence, and therefore that part of the evidence should be disregarded at the time of final arguments. Bring this out when you come back to court. So not only the document on the basis of which the questions have been asked, but also the evidence relating, that part of the evidence relating to that document must be struck off, whether it be in the chief or whether it be in the course of cross of your client. So chief of the opposite party and cross of your client, because you cannot have any part of the chief of your own client knocked off in this process. It has to be the chief of the opposite party and cross of your client on those documents, which you have to have crossed out. Second, you have to ensure that the document, which according to you is clearly inadmissible and has been, however, remained on the record, is also struck off and not part of the evidence which is marked by the court. However, if the reference to the Commissioner for Recording Evidence has been after the clarificatory judgment, the documents will have to be marked prior to reference to the Commissioner, then such a situation would not arise. What would remain is any part of the chief of the opposite party which ought not to be looked at because it's hearsay evidence or because it is not personal knowledge, and a striking off of that part, and consequently a striking out of any questions in cross of your client, which is in order to urge the correctness of that part of the chief which has been struck off of the opposite party, must also be brought to the notice of the court. Once the evidence has been corrected, or once the pleadings and the evidence have been corrected, that's what I should say. And if you find that the issues are not reflecting the real controversy, you can make an application under Order 14, Rule 5, and persuade the court to amend, add, or strike out any issue. This is the importance of the breaching of a lacuna or the correcting of a lacuna prior to final arguments. Because once you come to the stage of final arguments, you're one stage away, only one stage away from execution of an order. You have to get your house in order by then. When I say execution of an order, I stand corrected, execution of a judgment. You therefore have to get everything in place by this time. There was an arbitration matter which had come up before the late Mr. Justice Painse, when the only relief sought for by the claimant before Justice Painse as an arbitrator was that it be declared X, Y, and Z. The award therefore rightly reflected that it is so declared. But what is the executable order? What is the executable decree? None. A declaratory suit, if you are in possession, is fine. A declaratory suit, if you want to execute it and obtain possession, obtain an injunction or something like that, is useless. You therefore have to be very clear as to what the issues are and what the reliefs are. They have to be in sync. Once we are clear about the reliefs also being in sync with the case in the pleadings, the case made out in the course of evidence, and the case of your party being within the four corners of the applicable law. It's only then that the relief as prayed for can be granted or opposed. For bringing this aspect of the matter to the notice of the court, how do you go about the final hearing and final arguments in suits? An indication of this is available to us in the provisions of Order 18. First comes the statement of the case by the plaintiff. This is where you will have to set out your proposition of applicable law, proposition of law, given the facts and circumstances, the facts and circumstances reflected in your proposition of law, set out the pleadings, and set out the evidence. If you can, rely more on documents rather than oral evidence. The statement of the case has to be followed by the production of evidence in support of each issue. So there is an indication itself that the production of evidence is through examination of witnesses, but do it in a manner that the evidence that you lead, either by way of affidavit in chief or your cross-examination, deals with it issue-wise rather than here, there, everywhere. Because if you deal with it here, there, everywhere, issue 1, issue 10, issue 12, issue 2, issue 4, you will then have to sit and put it all together. It might be a manner of cross-examination to confuse the witness, that you don't deal with all questions seriatim, but you jump from one to the other. How do you overcome this? The manner in which I do it is, what are my cross-examination questions for each issue? Is there a common question for each issue which I want a particular answer? Then I only ask it once when I am nowhere near that issue. But I know that that is one answer I can use for all issues. It means a lot of work prior to final arguments. But that is one manner in which I am able to shorten my question, because I know that I can then use this answer if my question is framed in a particular fashion for more than one issue or more than one proposition of law. The second important thing which I have when I am, producing evidence in support of each issue is to have a sequence of dates and events. A exhaustive list of dates and events will give me a very important insight into the sequence of events which are required for supporting a particular proposition in favor of my client. Therefore, that exhaustive list, I look at it from the viewpoint of what is the sequence required, what is the sequence which existed, and why the case of the opposite party is correct or incorrect. If it be correct, how do I meet it? If it be incorrect, how do I highlight it? Therefore, this list of date also becomes very important. Because once this stage is done, I then am leaving the floor open for the other side to start their case. And they also do the same as me. And I, if I am the plaintiff, have a chance to reply for the full. If I am the defendant, I have to reply for the entire case in my one attempt. Oral arguments become very easy if I follow the sequence of list of dates and the sequence of propositions of law, issue-wise. As an arbitrator, what am I faced with? I'm faced with two things. Unfortunately, an absence of any list of dates, very often, so that I have to prepare my own list of dates, which I reflect in the award without drawing notice to the fact that there was an absence of a list of dates given to me by either party. And secondly, in culling out evidence issue-wise, I have to do it myself. Now, it becomes easy because the evidence is recorded before me as an arbitrator, or I have dictated the manner in which the evidence is recorded. But in court, where it is before a commissioner, and today we indulge in asking 2,000 questions because it is before a commissioner. Can you imagine the agony that a judge has to pass through before coming to the real issue without your assistance? So today, final oral arguments is something that a lot number of us have lost sight of whilst playing around with recording of evidence before commissioners. Hopefully, once we get down to the task of preparing oral arguments, and we appreciate the number of absolutely unnecessary questions, we ourselves will be able to regulate the manner in which we get evidence recorded before commissioners, so that you are fit in a better manner to prepare for your next final hearing. To sum it up, because I think my time is getting up, lacuna required to be filled in essentially before the recording of evidence. Don't give up, however, if it is already recorded and you still feel very strongly that there is something that your client must get the benefit of. Seek the indulgence of the court, not because you have a right or your client has a right in law, but you're seeking the indulgence of the court and appealing to the court. And in its quest for determining the real issue, these are factors which may require to be there before the court, and try and persuade the court to see the issue in the light that you are urging it to see, and do the needful. For preparing for oral arguments, apart from a reading of the pleadings and the evidence, what is most important, and I cannot emphasize sufficiently the importance of the benefit of you reading the pleadings and the evidence without it being reflected in a list of dates, is zilch. The benefit of your reading the pleadings and the evidence has to be reflected in a detailed list of dates. Everything, not issue-wise, everything. And thereafter, the preparation of sub-list of dates issue-wise. Once the sub-list of dates is there, you also have your note on the applicable law. You also have your note on the proposition of law, given the facts, and that is what you reflect in your written submissions. Why written submissions is the next question. Today, with the possibility of final arguments being through video conferencing, without you being able to be and see and gauge the mood of the court, read into the eyes of the court, the gestures of the court, it's necessary for you to have it on record. Not only for the ease with which the court can access what you have said, the ease with which a appreciation of the evidence is available to the court, but ultimately to ensure that your client's point of view is correctly put forward, fully appreciated, correctly put forward by you, fully appreciated by the court, resulting in a correct judgment all around. If it be a correct judgment, the benefit is to both parties. Both parties will hopefully not seek, in today's day and time, an appeal. There will be a saving of costs of both parties. There will be a liberating of time of the courts to deal with other matters. This is the ultimate benefit of overcoming lacuna and preparing well for the final lunch. Thank you very much.
Thank you so much, ma'am, for an impactful lecture. After listening to you, I would just say that strong women don't have attitudes, they just have standards. We have questions pouring in from all sections of the society. I'll go to the first question, ma'am, with your permission.
Sure, I hope I rise to the occasion.
You have already, ma'am, and it was a pleasure to have you on our platform. We were really looking forward to it. Yes, ma'am. So I'll go to the first question. The first question comes from Advocate Pratap Harugde. The question goes, the provisions of Order 18, Rule 17 of the CPC can be invoked only for the purpose of clarifying the material that has been placed on record in order to reach a proper conclusion and could not be invoked to fill up the lacuna in the evidence. What are the parameters to test whether the material is for clarification or otherwise?
See, Order 18, Rule 17. Order 18, Rule 17 or Order 6, Rule 17?
The question...
Order 18, Rule 17.
Yes, ma'am. Order 18, Rule 17.
Order 18 is at the time of hearing of the suits, and 17 is the court may at any stage of a suit recall any witness who has been examined and may, subject to the law of evidence for the time being in court, put such questions to him as the court thinks fit. Now, this is a court exercising its powers suo motu, because it feels that there is need to re-examine a witness. So are you referring to this, or are you referring to Order 6, Rule 17? Let me see. Order 6, Rule 17 seems to be more like it. Take a minute, I've got the CPC here, so let me have a look at it.
Yes, ma'am.
Order 5, Order 6, Rule 17. The court may at any stage of the proceedings allow either party or in such manner and in such terms, and such amendment shall be made by necessary. No application shall be allowed after the trial has commenced unless the court comes to the conclusion that in spite of diligence. Now, all right. So this is amendment. So I think it is Order 6, Rule 17. Now, clarificatory in nature or not, I am saying that there is no limitation on it having to be clarificatory. If you go to my Bible, I normally look at this. You just see the plethora of judgments that amendments can be across the board. They're even allowed amendments for inconsistent pleas. But you have to be able to persuade the judge that there is this plea which you are taking knowingly, and if the court feels that it is totally unnecessary, the court may in its order say, I'm allowing it subject to you having to face costs if the court at the final hearing finds that this amendment and the amount of time spent in evidence on this amendment far outweighs the need for such a amendment, because it was not addressing the real issue in question. So I don't think it is only clarificatory matters which need to be brought in under Order 6, Rule 17. Clarificatory matters, in fact, may be your argument that by this amendment, I'm only seeking an absolute clarification and a clear statement of what is already on record so that there is no waste of time. I hope I understood and addressed the question put to me.
Yes, ma'am. Thank you. And we have noted it. Coming to the second question, which comes from Advocate Praveen Parit. The question goes, the demurrer of Order 18, Rule 17 and Section 155 of the CPC enables the court to pass order for recalling if the witness at any stage for clarification of any doubt, leaving no scope for the plaintiff and the defendants to move court for recalling of the witness at any stage. Will it be right to say so, ma'am?
I don't think that is how one has to read the provisions of Order 18, Rule 17. The court is participating in the proceedings in court fully when it expresses a desire to recall a witness. That recall option is given to the court where the court finds that either party requires a particular course of action to be taken, is finding that that party is not taking that course of action, and therefore the law says the court is not helpless. The court can ask for a party to be recalled in order to clarify matters in its mind before it gives judgment. If and when the court recalls a witness, and depending upon the questions put by the court to the witness, any party finds it is an indication expressly put to them, which they now understand is exercising the mind of the court, the party can always apply to say that all the questions that can be put to this witness on recall by the court perhaps have not been put to him. With your permission, I too would like to put some questions to the witness recall. So that is always an application which is available to you. You cannot say that merely because the court has recalled a witness, you as a party are not going to be able to recall a witness, so provided there is scope for recalling of the witness.
Noted, ma'am. The next question comes from Advocate Manoj Mule, and the question goes, Order 41, Rule 27 of the CPC enables the appellate court to take additional evidence in exceptional circumstances. Whether this provision can be misused to fill up the lacunas of the proceedings.
I think we must always keep in mind that courts can see through misuse of provisions of law to pull a fast one on the other side, or trying and pulling a fast one on courts. Courts are not blind to these efforts on the part of us lawyers. 1. 2. I therefore said various applications can be made at a time which has not been specified in the court, provided your demeanor as an officer of the court is such where you're saying and acknowledging that perhaps there is no direct provision applicable to such an application being made, but that you are seeking the indulgence of the court in order to see whether there is need for the court to have the assistance of the result of such an application. Therefore, we have to approach this in a manner where it is not an exercise of a right, but it is in order to assist the process of the court. Once that is your underlying approach, and that is the underlying need which is being expressed to court, the court will look at it in similar fashion and give you elbow room directly at that point in time or at a later point in time. Now, just because there is a provision in the code that even at the appeal stage, amendments can be allowed, documents can be produced. You cannot sleep over the provision in law which gives you a right to make an application before the trial or at the argument stage and say, dekha jayega, appeal court mein dekha jayega. That may be mala fide in fact. That is the way I would look at this question which has been put to me.
Thank you, ma'am, and noted. The next question comes from Advocate Mohsin Mulani, and the question goes, whether the case is closed for judgment, whether that case can be reopened on the ground of ill health of the advocate, of the defendant, or on the count of change of advocate, whether that is permissible.
How true and correct is the plea of ill health of the advocate? What is my reputation as an officer of the court? What is the stage at which it is being urged? What must my conduct prior to the date on which the case was closed for orders? And what was the sense that you felt was the leanings of the court? All these are factors that come into play. It is not a cut and dried matter. In the Bombay High Court, we have the legendary example of a matter being closed for orders. The feeling of all parties concerned was that it was in favor of a particular party. The advocate of that party made an application to court to not pronounce the judgment because he had come across a judgment which was against the proposition that he was urging before the court and which he felt the court was tending to accept. This is an example of the Chief Justice of the Karnataka High Court when he was practicing in the Bombay bar. These are various factors, therefore, which will have to go into question. It's not a cut and dried thing. Like you can file a complaint. Nothing like that. It is all these factors that go into. Supposing a legendary, habitual person who's filing leave notes is seen to have appeared the day before and the day after, suddenly makes an application that I was not well on this particular day. Courts may take it with a barrel full of salt. But someone who is known to have faced an accident and not attending courts for 3 or 4 weeks, prior to which he was attending court regularly, or she was attending court regularly, may get the indulgence of the court. How do you make these sort of distinctions on a clear-cut basis? It's a case-to-case matter.
Noted, ma'am. Thank you so much. Coming to the next question, which comes from Advocate Santosh Khobre from Solapur. The question goes, Order 7, Rule 14, reading with Section 151 of the CPC, allows the plaintiff to place documents on record, which he relies upon at the time of presenting the plaint. If a document is found at a later stage, can it be brought on record at the final stage?
With the leave of the court, yes, that's what we discussed initially, no? That is one of the lacunas that I said you must be able to cite and be able to overcome. If it is a document which is required for the real determination of the issue before the court, convince the court about it. Because even I remember Justice Joshi saying, without the leave of the court, you cannot just produce it, unless, of course, it's going to be presented in cross. If it is a document which you can present in cross, try and make up a case for being able to show it in cross by giving notices under the provisions of Order 11 and Order 12. and hope and pray for no reply. And then produce it in cross if you can.
Noted, ma'am. The next question comes from Dipali Kadam. If a witness admits one document but doesn't admit its content, then how should one argue on that point?
All right. The moment a document is admitted, what part of the document is admitted when you say the contents are not admitted? That is one aspect of the matter about which you have to question, that the document you're admitting, but which part of the document deholds the content are you admitting, and which part of it is it that you're disputing? One. Two, as far as the correctness of the contents are concerned, you're going to be able to examine the person who prepared the document, who wrote that document, who acted on that document, or who reacted to that document. You also have that manner of proving the contents of the document and the correctness of the contents of the document, and therefore establish its probative value. Another manner in which you're going to be able to prove the contents of the document are if it is a particular document in a chain of documents, the Amir Ali judgment, that if there be a chain of letters and only one letter, which is an important letter, which is for you, which is not being admitted, you can say letter, reply, letter, reply, letter, reply. But why is this being negated? That is one. The chain link that is there, which is the Supreme Court judgment of the 50s. Another manner in which you can get the correctness of the contents and the correctness of the contents to be admitted is the corroborative value of the judgment because of its contents. The moment I admit a document, I am saying that yes, this document was written by X, Y, Z. Now the contents of the document could only have been known to X, Y, Z is something that you can ask a witness of yours to talk about, or you can bring it before the judge and say, who but the writer of this document would have known the contents of this document, and therefore the presumption under the Evidence Act that draw a presumption about the contents and the correctness of that contents. I think that Mr. Nafde also briefly alluded to this in his lecture yesterday, and he called it the authentication with reference to contents. That is the manner in which he introduced this aspect of the matter, if I am not mistaken.
Noted, ma'am. Thank you. Coming to the next question, which comes from Narendra Ramnani. The question goes, what if the documents are exhibited only because they are original, but no oral evidence is led by the plaintiff? What happens in such case?
The moment it is an original document, it is marked in evidence. All right, there is no evidence led about it by the person who produces the document. It is up to the opposite party to gauge the importance or the merits of such a document being brought on record without any evidence being led, and to either lead evidence to destroy the probative value of this document, which may be used at the time of arguments by the person producing the documents in the course of cross-examination of such person, or it is open for the person who has not produced the document to say that this document was produced. I have not admitted this document, despite which there is no evidence led in the chief about this document. This document, therefore, cannot be looked at. On the other hand, if it is a document which has been produced by A and has been admitted by the opposite party B, after such admission, A does not plead any evidence about A, about the document, except to say that B has admitted this document, then B will be disentitled to in any way condemn that document, and A can get the benefit of relying upon that document. It all depends on the course of events after such disclosure, no?
Noted, ma'am. Coming to the last question, which comes from Advocate Vikas Kare. The question goes, how to mark out the admission and the omissions from the evidence while preparing the matter for final arguments?
How to?
How to mark out the admission and the omissions from the evidence for final arguments?
Make a note of it in the margin and then highlight it in the course of your arguments. I'm sorry, I'm not able to appreciate what this question is. How do you mark out?
Yes, ma'am. The admission and the omissions from the evidence.
It would have to be on the merits of the case and the facts of each case. No? If your case is A and A is not admitted to directly, but everything which is around or which is required for A to exist. Let me give you an example. That in the course of a trial, if someone admits to being in Bombay for 6 months of the year and not in Bombay for 6 months of the year, and an incident which you rely upon occurred during the 6 months that that person was in Bombay, and it is your case that that person committed this, can a defense that I did not commit it because I don't stay in India or in Mumbai for a period of 6 months stand up in court? You have to then say the admission that he or she is in Mumbai for 6 months is an admission, and that admission can be proved by you by saying that during the 6 months which he or she was in Bombay, look at the electricity bills, look at the gas bills. These are the sort of things that you can bring on record to say that the date which I am relying upon is the 6 months that person was in Mumbai for. That sort of thing. And that, according to me, it's an admission, because that person who is denying the fact has not been able to destroy my case about the electricity bill higher being during this 6 months, or the whatever gas bill being higher during these 6 months, or whatever, that sort of thing. Corroborative value of your case.
Thank you so much, ma'am, for an impactful lecture. You remind me of Oprah Winfrey's famous lines, "Don't worry about being successful, just work on being significant and success will naturally follow." Thank you so much, ma'am, once again. Now I call upon Professor Deepa Vigyani to propose the vote of thanks.
Thank you, Vijaya.
It's Priyanka, ma'am.
Priyanka, sorry, my mistake.
Thank you, ma'am.
I can't see you.
Thank you, Priyanka. Good morning, one and all. Thank you so much, ma'am, for this wonderful, informative, knowledgeable, and insightful lecture. Ma'am, you completed our compendium of civil trials. Ma'am, as opening remarks, you spoke about your personal experiences and you tried to relieve the distress caused by this COVID situation. Ma'am, you marked the useful inputs from previous lectures of this unique compendium. Ma'am, you told us about the 7 steps of preparing for final arguments, hurdles in filling up the lacunas. Ma'am, you also spoke about the manners in which to approach the court, which is very crucial. You let us know about the probable objections and objections by opponent parties and the cost as well. Ma'am, you informed us about reframing issues as well, preparation of oral arguments, and importance of written submissions. I am here to express my gratitude. This is highly knowledgeable lecture, and I must confess the chat box is flooded with the praiseworthy words, and we want you back again and again on this platform with new topics and new, just to share your knowledge, and we are eager to listen it, ma'am. Beside thanking you, I would like to thank Sangli Advocates Bar Association, Advocate Vasantrao Patil Lawyers Training Center, the coordinating committee, the technical team behind this webinar. Plus, I would like to thank our lawyers participants and law students. Beside this, I would like to thank you, ma'am, for sharing your Sunday with us. We are just honored. We feel blessed to have you today. Beside this, I would like to speak my mind, if you allow me. This week coordinating committee termed it as a pink webinar because the lady speaker and women panelists we are having today. So with this positive note, thanking you, ma'am, expressing our gratitude, yes, and I seek your permission to conclude this webinar.
Thank you.
Thank you so much. I declare this